Do we have anyone in the jail that's ready? The jail court's on mute.
Sorry about that, Your Honor. Yes, sir. Ms. Beasley and all three of her clients are present and ready to go.
All right, Ms. Beasley, who do you want to proceed on first?
Mr. Hollinger.
All right, Mr. Hollinger, if you'll step up, please. This is cause number CR 21101. State versus John David Hollinger. Mr. Hollinger, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Make sure you speak up loudly and clearly so my reporter can take down everything that we say. Do you understand?
Yes, sir.
All right, thank you. All right, you are John David Hollinger, correct?
Correct.
Mr. Hollinger, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
I do.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
I am. Yes,
Do you
sir.
feel like you've had enough time to talk about your case with her and have all of your legal questions answered?
I do.
You have read through this paperwork and you understand everything, and that's why you signed it. Is that correct?
That's correct.
All right, Mr. Beasley, do you believe your client to be competent today?
Most definitely, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, sir.
And in this case, Mr. Hollinger is moving forward on a waiver of indictment. Is that correct?
Yes, sir. I've explained what that entails, and he wants to waive having his case presented to a grand jury.
All right, so Mr. Hollinger, you understand that you have the absolute right to have your case presented to a grand jury for them to determine if there's enough evidence to go forward in your case. And you understand that you may choose to waive that right. And is that what you're wanting to do today?
It is correct.
All right, Mr. Hollinger, the court finds that you have been charged by information with the second-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams. A second-degree felony carries a range of punishment of confinement in TDC not less than 2 years or more than 20 years, and an optional fine not to exceed $10,000. Do you understand that?
I do.
Understanding that full range of punishment, how do you plead to that charge?
Guilty.
And Mr. Hollinger, are you pleading guilty because you are guilty of that offense for no other reason?
Yes, sir.
Has anyone threatened you or forced you or pressured you to plead guilty to this charge?
No, sir.
All right, the court will accept Mr. Hollinger's plea of guilt. Ms. Beasley, any objection to States 1?
No, Your Honor.
States 1 is admitted in evidence, and the court takes judicial notice of the defendant's judicial confession. The court also finds that Mr. Hollinger has intelligently, knowingly, and voluntarily waived his right to indictment in this cause in open court. I'm going to take just a moment and look at the evidence, Mr. Hollinger. And Ms. Beasley, I don't see a lab report in here. Is Mr. Hollinger waiving the receipt of a lab report in this case as well?
He will judge if the DA doesn't have one. I don't have his.
Judge, we do have a lab back. If it was not included in the stipulation of evidence, that was our mistake. I can send it to Ms. Beasley and Ms. Taperham concurrently so that it can be added to the stipulation if there's no objection to that.
There's no objection from the defense, no.
And can someone just tell me what the lab revealed?
Judge, one of the 2 bags was tested, and it was 1.27 grams of meth. There was also a loaded syringe suspected to be methamphetamine, but the second bag and the syringe were not tested.
That's correct, Your Honor. Ms. Heisel and I did talk about that. I also gave that information to my client.
All right, then the court will ask that the state produce the lab report for inclusion in State's Exhibit 1. There being no objection from the defense, that will be included in State's Exhibit 1. Mr. Hollinger, based on that evidence, the court finds that there is sufficient evidence to convict you of this offense, and the court does follow the plea agreement in your case. The court convicts you of the second-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams. The court assesses your punishment in accordance with the plea agreement at 8 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a fine of $1,500, court costs of $290, and orders reimbursement fees of $15. Mr. Hollinger, the court awards you 174 days credit for the time that you have spent in jail on this cause already. Good luck to you, Mr. Hollinger. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence.
All right, thank you.
You're welcome, sir.
Thank you. Thank you.
Get that seat, Trevor.
Who do you want next, Ms. Beasley?
Mr. Burcham, Your Honor, is a plea.
All right, and before we call this case, State, has there been victim compliance with the proposed plea agreement in this case?
Your Honor, there is victim compliance. However, there is no return victim impact statement in this case.
Does that mean that y'all have been in contact with the victim or have not been in contact with the victim?
Judge, let me look to make sure, but I believe there was no response at all. Hold on. That's correct, Your Honor. There has been no response to our office at all from the victim.
Okay. All right. The court calls CR 2151, State versus Jeremy David Burcham. Mr. Burcham, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Burcham, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You may put your hand down. Make sure you speak up loudly. It's going to be very difficult for us to hear. Currently, the jail that you're in, the bandwidth is very low, so the connection's not very stable. So the audio is not good as a result, okay?
Understood.
All right, Mr. Burcham, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes,
Have you ever been diagnosed with any type of mental condition?
yes.
Can you tell me about that?
He has, Judge. If I may, Judge, I filed a motion for a 46B evaluation. He was found to have schizophrenia and was sent to the state hospital, was determined eventually with treatment to be competent, and came back.
Is he currently on any type of medications or undergoing treatment for schizophrenia?
Yes,
He is receiving medication. It has made a world of difference. He's been able to communicate with me, ask rational, logical questions, and he is much better at this point in time.
Thank you, Ms. Beasley. So, Ms. Beasley, do you believe him to be competent today?
I most definitely do, Judge.
Okay, and you have explained to him his legal and constitutional rights and discussed with him the advantages and disadvantages of a deferred adjudication plea?
I have, Judge. We've talked in great detail to make sure he understood everything. Also included his parents in those discussions, and they're aware of the consequences of the plea as well.
Thank you, Ms. Beasley. Mr. Bertram, are you pleased with Ms. Beasley's representation of you?
Yes.
Do you feel like you've had enough time to talk with her about your case and have all of your questions answered?
Yes.
All right, Mr. Bertram, I have to explain to you the range of punishment for a third-degree felony offense. You've been indicted with the offense of stalking, which carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas prison system and a fine not to exceed $10,000. That means if I approve the agreement today and place you on this deferred community supervision agreement that you've reached with the state, that if you violate your terms and conditions of your community supervision, the court, upon finding that, could revoke your community supervision and could assess your punishment anywhere within that range of 2 years to 10 years. Do you understand that?
Yes, I understand that.
Okay. All right. Having understood that then and understanding that full range of punishment, Mr. Bertram, how do you plead to the third-degree felony offense of stalking?
Guilty.
And Mr. Bertram, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
All right, the court will accept Mr. Bertram's plea of guilt. Ms. Beasley, any objection to states one?
No, Your Honor.
All right, states one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, Mr. Bertram, based on the court's review of the evidence, the court finds that there is sufficient evidence to convict you of this offense, but the court will follow your plea agreement and the court will defer a finding of guilt in your case and place you on community supervision for a period of 5 years. The court will assess a $1,500 fine. The court will also dismiss under section 1245 an evading arrest or detention with vehicle, cause number CR 20238. And the state is acknowledging the rejection, I suppose, of several unfiled cases that are reflected in the judgment. Court also assesses a fine of $1,500, court cost of $290, orders reimbursement of $1,030. And the court hereby commits you to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of your sentence. Good luck to you, sir.
Thank you.
Judges, if I may, just to let the court know, there's a few special stipulations on his probation. One is that his probation is not allowed to be transferred to another jurisdiction without the prior approval of Ms. Curry, the DA. Another one is that he's not allowed to have any contact with the victim in this case. And he's not allowed to have any weapons in his possession on this case. And then he has to also be supervised by the mental health caseload, be on the mental health caseload, and also comply with any treatment that's recommended by the Andrews Center in Canton. And true, there is an additional one that Ms. Burns told me about, and I forgot to add that to the list. He cannot get off early on probation. We've agreed to stipulation that he will be on probation on this case for 5 years.
And all of those are included in the conditions of community supervision?
Yes, sir.
All right, thank you, Ms. Beasley. Okay, court is,
Can you be excused, Your Honor?
yes, he may be excused. in that, put this in the discovery and the stipulation of evidence and John Hollinger. All right, this is cause number CR 19305, State versus Donald Brian Ellis, set for pretrial today. Ms. Beasley, go ahead.
Yes, Your Honor. We had an offer of 16 years prison time if my client chose to accept that offer as of today. He has decided to go against his attorney's advice and reject that offer. I've advised him that Ms. Curry said the offer would go up to 25 or higher if we don't accept it by today. I've also told him if he chooses to take it to a jury trial, which is obviously his right, that she's advised me that she will ask the court to stack whatever sentence he gets from a jury on top of his remaining parole time, which is 2047. He's indicated at the prior meeting that he wanted to have an additional DNA test. Do you still want me to do the additional DNA test against my advice? You understand? It's against my advice to do that. Okay. So I will need additional pretrial setting, Judge, to get information on that additional test that he wants completed before we'll be ready for trial. But I know he's been in custody for quite a while. So I know that we will be on the trial docket fairly quickly, but I do need to get that additional DNA test done.
You know how long it may take you? How much time do you need, Ms. Beasley, to get that additional DNA test information?
Judge, we had asked over a week and a half ago, something like that, if there was enough material even to be tested. And the lab hasn't called Ms. Curry back yet to give us the information whether we can even do that test yet. It's a small sample, so I need to find out if it's a large enough sample that it can be tested. So I'm gonna say at least 60 days.
At least 60 days? How about we do 30 to get a status? How about 30 in a status?
That'll be perfect, Judge.
Do you know when you're coming back? Are you coming back in May at all? May 11th, perhaps?
Check, Judge. I think that I may be. I am, Judge.
On May 11th?
I will be here.
All right,
Yes,
well,
sir.
I know we may not have it done by then, but let's set it for May 11th. And at least we'll have an update, hopefully from the lab on
Yes, sir.
there's enough there to test, and two, if there is, then how long that may take.
Yes, sir.
And we, once we get through this issue, then, you know, the court may look at finding some time available to get Mr. Ellis to his jury quickly. Since this is an aggravated sexual assault, it will take a priority on the trial docket. Now, I do have special settings throughout the year, but some of these cases I believe are being resolved. So he may get his jury quicker than anticipated.
I tried to explain that to him, Judge, but thank you.
You're welcome. All right, so we'll see you back on May 11th, and hopefully we'll have an update for DPS.
Yes, sir. Thank you.
You're welcome.
Have the excuse, Your Honor.
Yes, ma'am. Thank you, Ms. Beasley.
Thank you.
That's why I said eventually, I'll get it to you, but the judge has the paperwork physically at the courthouse right now.
Do we have anyone else in the jail ready?
Yes, Your Honor, we have Mr. Sanders and Mr. Heron ready.
Sorry about that. Can somebody come get Beasley's 3 and maybe bring Richardson?
All right, Mr. Sanders, are you ready on all of Mr. Heron's cases?
Yes, Your Honor, we are.
And is this going to be a plea today?
Yes, Your Honor, it is.
Can you walk me through which cases he's putting on and the terms?
Yes, Your Honor. In CR 19-00081, he'll be pleading guilty to the arson charge and for a 15-year sentence. And then with that, and a $1,000 fine. And then with that, other cases will be 1245. It'll be cause number F19-00018, and that's burglary of a building. And then CR 19-00079, theft of a firearm. And then CR 19-00080, and that's theft of property. And then CR 21-00100, and that's the bail jumping. And then one unindicted case, it's temporary number, intake number F1800675, and that's an engaging case.
You said that was F1800.
Yeah, 00675.
Okay, and there was one burglary of a building that I don't have on my docket. Can you read? I think you said
Okay.
CR 19181, maybe?
F19 00018.
F190018. You said that was a burglary of a building unfiled.
Oh, no, that one was filed in. It was filed in county court law, but then we had transferred it. We had filed a motion to have it transferred to your court with all the others.
Okay, well, I guess but so what's the cause number on the burglary of a building? So it's F19-18?
Yes.
All right, because I don't have that on my docket, so, but you're telling me it has been transferred?
Yeah, you're right. Yeah, some time ago.
Okay, and what's the court cost?
Let's see, $290.
Any reimbursement fees?
$100.
100? And what about
Yeah.
any jail credit?
On this one, 817 days.
All right, so that's the only one he's pleading to, correct?
Of the new charges. Then there's a probation revocation, CR 18-00013. And so he's pleading true to those violations. And it's for a 10-year sentence to run concurrently with the 15 on the arson case.
So he's pleading guilty in CR 1981 to arson, first degree felony. And he's also pleading true to the allegations in the motion to revoke in CR 18.
Judge, on the arson case, I forgot to mention this, the state agreed to abandon the enhancement paragraph. So it's just a second degree arson, 2 to 20 years. And also, and I don't think this is anything that necessarily is going to affect the court, but I believe everything should be changed as far as the CJIS code for the arson. I think the indictment says, at the top of the indictment, it says causing serious bodily injury or death. The language in the indictment doesn't say that. So I think there may be, at some point along the way, the wrong CJIS code was entered regarding the type of arson, but it is a second degree felony. The enhancement of the prior prison trip, that paragraph, the state agreed to abandon that.
Okay. All right. So
And that may have been very.
okay, so let me repeat. He's pleading guilty to a second degree felony arson, not causing any type of bodily injury or death, just straight arson.
That's correct. Yes.
And the recommendations, 15 years TDC, $1,000 fine, $290 court cost, 100 reimbursement, 817 days credit, with the state abandoning their enhancement paragraph.
Yes, that's correct.
Okay. And then CR 1813 Revocation, please true, in exchange for 10 years TDC with balance of a financial obligation. And what level is that? It must be either a third or a second. Is that a
It's third degree.
third degree? Okay. And then the 1245s will be the theft of firearm, the theft of property, filed bail jumping, filed burglary of a building, unfiled engaging. That sound right?
That's correct.
I believe that wraps it up.
Yes.
Okay. All right. So Mr. Heron, raise your right hand. I'm going to place you under oath. Mr. Heron, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You got to say it louder. I can't hear you.
Yes, sir.
Okay, thank you. The bandwidth, you put your hand down. The bandwidth is low and so it's not working very well. Make sure you speak up as loud as you can so my court reporter can hear you so she can take down what you see. All right, Mr. Heron, you heard the agreement that Mr. Sanders stated to the court. Is that your understanding of the plea agreement that you want to enter into today?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your cases with him and have all of your legal questions answered?
Yes, sir.
And Mr. Sanders, do you believe your client to be competent today?
Yes, sir, I believe it is.
And you've explained to him his legal and constitutional rights?
Yes, sir, we've gone over all of his rights.
And does your client waive the formal reading of the state's motion to revoke in CR 1813?
Yes, sir, we would waive the reading of the motion to revoke.
All right, Mr. Heron, with regards to CR 1981, you've been charged by indictment with the first-degree felony offense of arson causes serious bodily injury or death, with the state abandoning their enhancement paragraph and with Mr. Sanders' statement to the court, it appears that the charge in this case is a second-degree arson, which carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas state prison system. Do you understand that?
Yes, sir.
The court would also impose an optional $10,000 fine. Understanding that, let me ask you, how do you plead to arson?
And Judge, did the court say 10,000? It was $1,000.
Yeah, no, I'm telling him what the range of punishment is. I told him
Oh,
the
okay, okay.
punishment was not less than 2 years or more than 20, and that the court could impose an optional fine not to exceed 10,000. No, I haven't pronounced sentence yet. That's just the range of punishment. So I'm asking, does he understand the range of punishment?
Yes, sir.
Okay, so understanding that range of punishment, how do you plead to the charge of arson?
Guilty, Your Honor.
All right, Mr. Heron, are you pleading guilty to that charge because you are guilty of committing that charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to that charge?
Oh, no, sir.
All right. Court will accept the defendant's plea of guilt in CR 1981. Mr. Sanders, any objection to states one, the admission of states one in that case, the stipulation of evidence?
No objection.
All right, the court admits states exhibit 1. It takes judicial notice of the defendant's judicial confession. Mr. Heron, with regards to the motion to revoke, how do you plead to the counts alleged by the state in their motion to revoke? Are those counts true or not true?
True, Your Honor.
And are you telling me that those counts are true because in fact they are true because you committed those counts?
Yes, sir.
And has anyone threatened you or forced you or made you feel like you had to plead true to any of those counts?
No, sir.
All right. Court will accept the defendant's pleas of true in CR 1813. Mr. Sanders, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A in that case?
No objection, Your Honor.
All right, State's Exhibit A is admitted. The court takes judicial notice of the defendant's judicial confession in that matter. Is there anything further from the state,
No, Your Honor.
from the defense?
Judge, with regard to CR 18-13, the revocation, on that, he has more credits than on the arson case. He has 928 days credit on that case, on the revocation.
Thank you, sir. All right, anything else, Mr. Sanders?
No, Your Honor.
All right, State, can you give me the summary evidence to support the plea?
Yes, Your Honor. There was an investigation following a burglary and an arson of a home here in Van Zandt County that originally started out with some of the stolen property being recovered. The person who was in possession of that stolen property named Mr. Heron and one other individual as the people who were responsible for that burglary and arson. There were several interviews with multiple different suspects who multiple people named both Mr. Heron and the co-defendant as the persons responsible. The investigating agency also located photos of Mr. Heron posing with some of the items that were stolen out of the house prior to its being set on fire. After that, the Van Zandt County, I believe it was the sheriff's office. This was not originally my case, Your Honor, so forgive me if I'm wrong about the agency, but I believe it's the sheriff's office obtained a warrant for Mr. Heron's arrest.
Mr. Sanders?
No objection to that, Judge.
All right, based on the evidence presented to the court finds that there's sufficient evidence to convict Mr. Heron of arson. The court will follow the plea agreement that the state has reached with the defendant and is recommending to the court. The court hereby convicts Charlie Franklin Heron IV of arson. I'm going to pause for just a moment. Having convicted him of arson, the court hereby assesses his sentence and punishment at 15 years confinement in the Texas Department of Criminal Justice Institutional Division, orders a $1,000 fine, $290 court cost, $100 reimbursement. Court awards Mr. Heron 817 days credit towards his sentence for time served on that cause. The court in CR 1813, having found that accepted and found Mr. Heron's violations to be true, the court hereby, upon that finding, finds that he violated his conditions of community supervision, hereby revokes his community supervision, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, orders that this sentence be run concurrent with the sentence in CR 1981, and awards him 928 days credit towards his sentence in that cause. The court finds that the cause number CR 1979, CR 1980, F 1918, and CR 21-100 have been taken into consideration under section 1245 of the Texas Penal Code, and the state is also resolving F 18675. Mr. Heron, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Please go with the bailiff to be fingerprinted. When you get out of TDC, it's important that you report to the courthouse so that you can make arrangements to pay the monies that you owe. Good luck to you, sir. We have anyone else available?
No, Your Honor, we're gonna need a few minutes to do a switch out.
Okay, thank you, ma'am.
Yes, sir.
Oh.
For just me or the whole thing? Just the jail court, okay, yeah. Okay. Okay, will do.
What's up, Karen?
He wants to shut down the jail court. because he can't really-
Hey, this is Aaron. I guess we're down to 4. We've got 2 people and 2 guys, is that correct?
Actually, I guess it doesn't. No, I need a few more minutes.
Do what?
No, I need a few more minutes, I'm sorry.
Okay, that's fine. We've got some others coming up. Your Honor, does this sound any better?
Yeah, it's better. It's better.
Okay. Very good. We need just a couple of minutes. We've got another group that's on their way up, but they're not here just yet.
No problem. All right, the court calls cause number CR 2405, State of Texas versus Christina Munoz. Ms. Munoz, I'd called your case earlier today. How come you weren't here at 9 a.m.?
I'm there, I'm not advocating for the we just, us, the family were going through like a huge tragedy right now. My brother that I like awfully close to, he passed, right? So we've been dealing with a lot of funerary.
I understand that, and I'm sorry to hear that, but the best way to be there for your family is to take care of your responsibilities so you don't find yourself getting rearrested and put in jail during this time where your family needs you. Understand? Your attorney, Mr. Knoll, was here earlier, and he asked me not to find your bond insufficient. He asked me not to have you rearrested, and that's why I gave you till 1:30. All right, so the court expects you to be here when I tell you to be here, okay? So my staff has already had you sign a notice of setting. You have the yellow copy, right? And you've signed your conditions of pretrial release. So you're due back before the court on May 11th at 9 a.m. All right, if you're not here at 9 a.m., I'm just going to find your bond insufficient or find that you just didn't honor your obligations to the court and issue a warrant for your arrest, okay? I'm going to order you to report to the Van Zandt County pretrial officer. All right, so you signed that pretrial release form today. I'm going to order you to report to them before 5 p.m. or before 6 p.m. on Monday. So they're closed today and tomorrow. So they're open from 7 to 7 on Monday. So before 6 p.m., I need you to report back over there to that building, and they will give you more information. All right, you're free to go. All right, are we ready with Mr. Adams?
Yes, Your Honor.
This is Mr. Richardson.
Yes, Your Honor.
All right, this is cause number CR 19-125, State versus Chris Michael Richardson. And we're set for a plea today. Can you tell me what those terms are, Mr. Adams?
Yes, Your Honor. It's CR 19126. The arrangement is a plea of truth to the allegations contained in the state's motion to adjudicate for Mr. Richardson to be adjudicated guilty, for his community supervision to be revoked, for punishment to be assessed at 7 months confinement in the state jail division, for the balance of the financial obligations to be repaid after his release, and for the state to reject unindicted felony case DA control number. Let me know if I'm going too fast.
No, you're fine.
Okay. To reject unindicted felony case DA control number DA 2021-0120, which is an unlawful possession of a firearm by a felon charge, and DA control number 2021-0405, which is a deadly conduct through firearm charge as part of the agreement. The original fine from 2 years ago was $3,000, with court costs of $453. toward the 7 months, Mr. Richardson's 79 days credit.
Thank you, sir.
There is an addition to that, an unindicted possession of a controlled substance state jail case. We are pleading to an information. It's been given cause number CR 2100102.
You said that's possession of controlled substance,
Yes, sir, less than 1 gram.
state jail felony.
Yes, penalty group 1, state jail felony.
Okay.
In exchange for Mr. Richardson's plea of guilty, punishment will be assessed as 7 months confinement in the state jail facility. Time to run concurrent with his 7-month sentence at CR 19126. And in this possession case, Mr. Richardson has 77 days credit.
Any fine on that possession case?
No fine, court costs of $290, reimbursement fee of $15.
15?
Correct.
All right. All right, Mr. Richardson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you speak up. You can put your hand down. Make sure you speak up loudly and clearly so my court reporter can hear you. Okay. All right, Mr. Richardson, you heard the terms that Mr. Adams had given to the court. Is that your understanding of the plea agreement in each one of your cases?
Yes, Your Honor.
And Mr. Adams, does Mr. Richardson, is he going to be waiving the formal reading of the state's motion to adjudicate?
That's correct, Your Honor. We were going to waive that reading.
And is he going to be pleading true to all counts?
Pleading true to all counts.
Okay. All right, Mr. Richardson, let me inform you that in cause number CR 2100102 for the state jail felony charge of possession of a controlled substance in penalty group 1 less than 1 gram, that the range of punishment in that case is confinement in the Texas Department of Criminal Justice State Jail Division for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. That's the legal range of punishment that your sentence must fit within. Do you understand that?
Yes, Your Honor.
All right. And Mr. Richardson, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
Yes, Your Honor.
What have you been diagnosed with?
Bipolar and schizophrenia.
Are you currently on any types of medication or undergoing any treatment for bipolar and schizophrenia?
No.
No?
Correct, Your Honor. Your Honor.
And do you feel like the fact that you're not on any type of medication for those disorders today in any way is inhibiting your ability to have a rational understanding of the proceeding today and what's going on in your cases?
No, Your Honor.
You are
Your Honor,
represented. Go ahead, Mr. Adams.
to the extent of, or to the issue of Mr. Richardson's legal mental competency, this is the first I'm hearing of diagnoses of those two specific conditions. I've had several conversations and discussions with Mr. Richardson about his legal situation, the cases on which I'm representing him. I've never had any question or second thought as to whether or not he is legally competent. I've always believed in my interactions with him that he is legally competent.
And you believe him to be so today?
I believe he is today. Yes, sir.
Thank you. And while I'm speaking with you, have you explained to him his legal and constitutional rights?
I have.
Okay. And Mr. Richardson, are you pleased with Mr. Adams' representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about both of your cases and had all of your questions answered?
Yes, Your Honor.
Okay. Then to the charge of possession of a controlled substance in penalty group 1 less than 1 gram state jail felony, how do you plead to that charge?
Guilty, Your Honor.
And Mr. Richardson, are you pleading guilty because you are guilty of that offense?
Yes, Your Honor.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
All right, then the court will accept the defendant's plea of guilt in that charge. Mr. Adams, any objection to States 1?
No objections, it's marked it off.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Richardson's judicial confession in that charge. Mr. Richardson, with regards to cause number CR 19-126, you've reviewed the counts alleged in the state's motion to adjudicate with your attorney, Mr. Adams, haven't you?
Yes, Your Honor.
How would you plead to those counts? Are those counts true or not true?
Yes, Your Honor, true.
And are you telling me that all of those counts are true because in fact they are true?
Yes, Your Honor.
And has anyone threatened you, forced you, or pressured you to make you feel like you had to plead true to any of those counts?
No, Your Honor.
All right, court will accept the defendant's pleas of true in that case with regards to the state's motion to adjudicate. Mr. Adams, any objection to the defendant's waiver of rights and plea of true as states Exhibit A?
No objection, it's marked it off.
States A is admitted, and the court takes judicial notice of Mr. Richardson's pleas of true to each count alleged. Is there anything further from the state?
Judge, we have nothing else to add in either case. We would rest and close in each case.
Thank you, Mr. Woodwhite. Mr. Adams, anything further on behalf of your client?
Nothing further in either case, Your Honor. We rest and close in each.
All right, and if the state can give me a brief evidentiary summary of the possession case.
Judge, Mr. Richardson was riding his, I believe his motorcycle. The officer in question, I believe Wills Point or perhaps Grand Saline, I don't have it right in front of me. They recognized him. They recognized he had warrants for the two cases that are being taken into consideration. They went to arrest him and found I believe a vial of methamphetamine and a syringe in his front pocket. That's basically the summary of that case.
And the lab came back as reporting what?
Judge, we do not have the lab back in this case.
And Mr. Adams, is your client waiving the receipt of the laboratory in this case?
Yes, Your Honor, that's correct. In light of what Mr. Richardson seeks to accomplish and putting this behind him as quickly and expeditiously as possible, we are waiving any right to have a lab test result in this case.
Judge, I would note, I believe it weighed at 0.90 grams field weight. I'm assuming that involved the whatever container, so it would be obviously less than 1 gram.
And it advises me that he admitted to the officers at the time of his arrest that what was found in his pocket was methamphetamine.
Thank you, Mr. Adams. Okay. All right, then based on the evidence in CR 21-102, the court will find that there is sufficient evidence to convict Mr. Richardson of the charge of possession of a controlled substance in penalty group 1 less than 1 gram. The court assesses his sentence, convicts him and assesses his sentence at 7 months confinement in the state jail division of TDC. Court does not assess a fine, but does order court costs of $290 and $15 reimbursement fee. And the court awards Mr. Richardson 77 days credit towards his sentence for time served previously in this cause. With regards to CR 19-126, the court will find that Mr. Richardson, having been placed on this court by this court on community supervision, has violated the terms and conditions of his community supervision. The court hereby adjudicates his guilt on the state jail felony offense of abandoning or endangering a child with criminal negligence. The court revokes his community supervision and assesses his punishment in accordance with the plea at 7 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations. And the court finds that DA numbers 2021, 120, and 405 have been taken into consideration with the defendant's plea in this case. Mr. Richardson, I'm going to have you step over with my bailiff to be fingerprinted, after which you'll be remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, that's the only matter I had on the docket today. I do have a question for off the record.
Okay, we'll be off the record, but on the YouTube record.
That's fine. That's fine. It's just about our kickoff time on Monday morning. I'm not sure if it's 8:30, 9, 10.
Well, so I'll have the jurors there reporting about 8:30. So we'll be bringing them early and getting them situated. I usually try to get started with excuses and those things about 9 o'clock at the latest. So usually get them in here about 8:30 and let them get settled and then start forming my lines of excuses and exemptions, things of that nature. So you're welcome to be here as early as you want. The doors are open at 8 o'clock. And if you want to be here for any of that process, you're welcome to do that. Otherwise, I would say, right around 9 o'clock is when we'll get started.
Okay, very good.
And Mr. Adams, so what I'm planning on is 1 hour per side for voir dire. And I know that there's some probably issues that I've spoken with Ms. Curry just about logistics, and I know 1 hour may be kind of a time constraint, but I'm bringing in a large panel that day and hoping to get 2 juries selected. So we're going to have to be efficient in the morning so that I can resume promptly in the afternoon and pick my second trial for 2 weeks from now. So I'll go ahead and tell you, I'm going to give you 1 hour and just ask that you work within that time constraint. And I'll do my best to help corral the jury if they get out of control with questions or anything like that.
All right. It's been since December of 19, so I'm going to be a little rusty, but I'll do what I can.
I think we'll all be rusty. I couldn't even remember how to get in the court room until about 2 weeks ago. So we'll get back up. All right.
All right. Then. We'll see you Monday morning.
Good morning. Who's next? Bailiff.
I do have both of Ms. Thompson's clients in the room.
Okay, let's go ahead and bring Ms. Dean up. All right, this is cause number CR 2288, State versus Mary Louise LaCole Dean. Ms. Dean, will you raise your right hand so I can place you under oath? Ms. Dean, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Please speak up loudly and clearly so my court reporter can hear you. Ms. Dean, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
No, Your Honor.
And in this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you? And do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed that you do not understand?
There was one document, Your Honor, that had something on it, but she said she would try to fix it. So I understand it. Yes, Your Honor.
Ms. Thompson, do you know what your client's talking about?
Yes, Your Honor, it's on the Michael Morton, the discovery thing. She was claiming that one of the convictions from Kaufman County she did not have. I explained to her that form was basically to let her know what the state had provided to me to get ready for trial. But I was headed to the DA's office, would make sure that they had that issue brought up to them. I also emailed Ms. Heisel. We did discuss it by email, and I believe it was addressed appropriately, Your Honor.
Okay. All right. So, Ms. Dean, you feel like you understand everything that you've read and signed and discussed with Ms. Thompson?
Yes, Your Honor.
All right. And Ms. Thompson, do you believe your client to be competent today?
She is competent, Your Honor.
And you've explained to her her legal and constitutional rights?
Yes, sir, I did.
All right, Ms. Dean, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. That's a state jail felony in Texas, and that carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice. Also carries an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
Understanding that range of punishment, this time I'm going to ask you, how do you plead to that charge? Are you guilty or not guilty?
Guilty. Your Honor.
You said guilty?
Yes, sir. Yes, Your
All
Honor.
right. And Ms. Dean, has anyone threatened you or forced you or pressured you to plead guilty to this offense?
No, Your Honor.
All right, the court will accept Ms. Dean's plea of guilt. Ms. Thompson, any objection to states 1, the stipulation of evidence?
None, Your Honor.
All right, the stipulation of evidence is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, just a moment to look through the discovery.
Stop.
Hey, is there a lab report in this case? There's not one in states 1.
Judge, I believe there is. I'll check and get you an answer real quick. Yes, Your Honor, there is. It shows 0.12 grams of methamphetamine. And with permission, I will email Ms. Thompson and Ms. Tabraham a copy of this to be included in the stipulation.
Ms. Thompson, do you have any objection to that being included in State's Exhibit 1?
No, Your Honor. No, Your Honor. I already have a copy of it.
All right. All right, Ms. Dean, then based on the evidence before the court will follow the plea agreement in your case. Court finds that there's sufficient evidence to convict you of this offense, and the court does convict you of this offense and assesses your punishment at 10 months confinement in the Texas Department of Criminal Justice State Jail Division, orders you to pay a $1,000 fine, orders you to pay $180 restitution, $290 court cost, $35 reimbursement fee. The court awards you 80 days jail credit for the time that you have spent in jail in this cause towards your sentence. Ms. Dean, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. Good luck to you.
Thank you, Your Honor.
You're welcome.
Hey, guys.
Is this Ms. Carter?
Yes, Your Honor.
All right. Court call CR 20204, State versus Anne Marie Carter, and we're set for arraignment today, I believe. Is that correct?
That's correct, Your
Yes,
Honor, and
sir.
also a motion to release bond.
Okay. And have you presented the indictment to your client yet, Ms. Thompson?
No, I have not, Your Honor. I just recently got the indictment, Your Honor.
Ms. Carter, can you see this document I have on the screen?
Yeah.
Move it. Stand on it.
Yeah. Yeah, I can see it now.
Okay. So for the record, I'm having displayed the indictment and cause number CR20-204. I'm gonna give you a second to read this, okay? And you let me know if I need to move down or slow down.
I can't really see on that side because of the thing. Can you scoot it that way?
Okay, there we go.
Okay.
Have you been able to read the entire document?
Yes.
That ends with a signature?
Yes.
Okay, and let me ask you, Ms. Carter, is your name spelled correctly here in this indictment?
There's not supposed to be a space in between the "and" and the "Marine."
So is your first name Anne Marie?
Yes. Yes, sir.
Do you have a middle name?
No, sir, I do not.
Okay. All right, do you understand that you've been charged with the offense of intentionally, knowingly possessing a controlled substance? The state's alleging to be methamphetamine, and the amount they're alleging is 4 grams or more, but less than 200 grams. Do you understand that charge?
Yes, sir. I understand the charge.
Okay, and the level of charge is a second-degree felony offense under this code. And a second-degree felony offense carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries an optional fine not to exceed $10,000. Do you understand that, Ms. Carter?
Sir.
All right, and so Ms. Thompson would like to enter a plea of not guilty. Is that correct?
That is correct, Your Honor.
All right, the court will enter Ms. Carter's plea of not guilty into the record, and the court will set this matter for pretrial. Are you available on May 11th, Ms. Thompson?
Yes, sir, I'm showing that I am available for the day.
All right, court sets this matter for pretrial on May 11th. All right, now that takes care of the arraignment. All right, with regards to your motion for bond reduction, have you served that on the state, and have they had their 3 days notice? State?
Judge, I don't have a copy of it, but I can't say for sure that it hasn't been sent to the DA e-file drive. However, Ms. Thompson and I have talked about this, so I'm ready to proceed.
Okay. Would you like to call your client, Ms. Thompson?
Yes, I would, Your Honor.
All right, Ms. Carter, if you will, raise your right hand. I'm going to swear you in for the purposes of this hearing. Ms. Carter, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sorry.
Okay. You hand down, make sure you speak up loudly and clearly so that I can hear you and my court reporter can hear you, okay?
Yes, sir.
Go ahead, Ms. Thompson.
Ms. Carter, go ahead and state your full name again for the record.
Anne Marie Carter.
And you understand we're just calling in for check on getting your bonds reduced today. Do you understand that?
Yes, ma'am.
Okay. Ms. Carter, do you have a job?
I did have a job before I came to jail. I mean, I don't now, I'm sure, because I lost my job because I came to jail, but
Okay. What were you doing for employment?
I clean houses for the maids. It's in a company out of Mesquite.
Okay. Have you talked to them to see if you would have your job if you were to gain a release?
No, ma'am, I haven't because I don't have any phone numbers. I didn't know what number to call.
Okay. If you were to
I've
get
been
released, where
working
would
for
you
them
be?
for 7 years. I've been working for them for
Ms.
7
Carter.
years, so I mean,
All right.
sorry.
Ms. Carter.
Here we go. Time out. All right, ladies. So I know the internet, Zoom, it complicates things. So we got to talk one at a time. So let Miss Thompson's going to ask her question, and then she's going to pause for a second or two. Then you answer Ms. Carter, and then when Ms. Carter stops, give her a second or two, Ms. Thompson. Otherwise, there's not going to be a transcript of what you're saying because my court reporter can't take down when you are talking over one another. Okay, so go ahead and ask your question again, Ms. Thompson.
Ms. Carter, where will you be living at if you get released?
With my stepfather at 1100 Highview, Ball Springs, Texas, 75217, or my bad, 75181, my bad. 75217 is where they
Is
go.
that
75. I'm sorry, I'm just nervous.
is that
1100 Highview, 1100 Highview, 75181, Ball Springs, Texas.
is that
Sorry,
Dallas
I'm
County?
Yes,
Ms.
ma'am.
Carter, do you have a car?
Yes, I do. But it's
Well,
not my car, it's my boyfriend's car, but I have access to a car. It's my boyfriend's car, but yeah.
okay. So if you were to gain release, you would have a way to come back to court for all settings and hearings. Is that correct?
Yes, ma'am.
Have you tried to contact any bondsmen to see what it would take to make bond on what they currently are?
I've had my boyfriend has, and he said that they also just getting a bond reduction, but he said he's got a little bit of money saved up for my bond, but he's waiting to see if I can get a bond reduction.
Okay. And just to clarify for the court, one of your bonds is $25,000 for the possession of controlled substance less than 200 grams charge. Is that correct?
Yes, ma'am.
And $75,000 for assault on public servant. Is that also correct?
Yes, ma'am.
And $75,000 for attempted escape. Is that correct?
Yes, ma'am.
Okay. Are you able to make even close to that on that kind of bonds?
No, ma'am. No, ma'am.
Okay. You just mentioned your boyfriend. Apart from him, do you have any of the family or friends that could try to assist you to come up with bond money?
Not that much. I mean, the $25,000 bond may be close, but I mean, but the $75,000 bond, two $75,000 bonds, no. I mean, that's $150,000.
Okay. Are you asking the court today to consider you for a PR bond?
If possible, because I got 5 kids at home, and my mom really needs help taking care of them.
Okay.
My
Are you telling the court that if it lowers your bonds, that you will report for all settings and all hearings?
Yes, ma'am, I will.
Did you also call my office this afternoon and leave a message that you planned on going into a
Yes.
rehab today?
Yes, ma'am, I do. It's called Grace Place. It's in Duncanville, and yes, I do. That's where
Have you been in contact with those?
My boyfriend has.
Have you been
My boyfriend has been in
Okay.
contact with them, and they're trying to get me a bed open there.
I'll pass the witness, Your Honor.
State, any questions?
Yes, Your Honor. Ms. Carter, I show that you have been in jail for 19 days on these offenses. Does that sound accurate to you?
No, ma'am, 'cause I was in Dallas County for a week and a half before I got transferred here.
Okay, but does it sound about right that you were arrested or brought to Van Zandt County on March the 12th?
Plus, but I was arrested on the 5th, ma'am.
Your Honor, I pass the witness.
Ms. Thompson, what was
All
the,
right.
go
I'm
ahead.
sorry, sir.
No, go ahead.
That's, I don't have any more questions, Your Honor.
And so what was the amount that you were asking the court to set her bail in?
Well, she was asking the court to consider PR bonds and, but I believe that she said that she could maybe come up with a $25,000 bond. I think that, Your Honor, I think 5,000 on each one of these charges would be sufficient.
Okay, all right. The court's going to take the evidence under advisement, and the court will issue a written ruling at the conclusion of the docket today.
Thank you, Your Honor.
All right, well, if Ms. Carter, if you make bail, your next hearing on May 11th will be at 9 a.m. If you're still in jail, it will be at 1:30. Do you understand?
Yes, sir.
Okay.
Your Honor, do you want me to stand by to find out the conclusion of that?
No, ma'am, that's okay. Well, I'll have the order sent to you.
All right, thank you, Your Honor. May I be excused?
Yes, ma'am. Just 1 second. Bailiff.
Yes, sir. Yes, sir.
All right, bailiff, I'm ready for the next one.
Yes, Your Honor, we have both the two remaining gentlemen left, Mr. Goodjoint for Mr. Weiner, Mr. Brenner for Mr. Wood.
I don't see Mr. Wood here today, so we'll go with Mr. Weiner.
Thank you, Judge.
All right, this, we'll give him a chance to get on up here and get settled. It's caused CR 20388, State versus Jonathan Roland Goodjoint.
Yes, Your Honor. May I proceed with arraignment?
Yes, please.
Your Honor, I've been over the charging instrument. My client's name is spelled correctly. We understand the nature of the allegations alleged against him. Would waive formal reading at this time and enter a plea of not guilty.
All right, the court will enter Mr. Goodjoint's plea of not guilty into the record, and we will set this matter for pretrial on May 11th. 1:30 if Mr. Goodjoint is in jail, 9 a.m. if he is on bail.
And Your Honor, there is something not on the docket that I've spoken with the state about. I'd like to discuss briefly with you regarding the case.
Okay.
Just to save you a really long story, we have an agreement to reduce my client's bonds to $1,000 surety bond on each of his charges. I have an order that states that it's agreed by the state, ready to email to you. And so I wasn't sure if you wanted me to email you that or e-file rather. But I just need to get that to the court for you to sign off on it.
I think e-file is probably the best. That way everyone gets serviced on that.
Okay, I will go ahead and e-file that right now.
And you said on both of his cases, because I only see one on the docket.
There's only one on the docket, but he also has essentially a tampering charge that has a $10,000 bond. It's a really unique situation, and I spoke with with Tyler rather, and he was agreeable to a $1,000 surety bond for each of the charges that he's being held on in the jail.
All right, so give me some explanation. So $1,000 on bail jumping.
Yes, Your Honor. So I spoke extensively. Obviously, I subbed in for Mr. Now. I've spoken extensively with him, and he is of the opinion that Mr. Goodjoint was not aware of the hearing, and the hearing that he's alleged to have missed. He has communication with our client regarding him having COVID or basically quarantining because of COVID. And, you know, Kurt basically told myself and Tyler that he honestly believed that it wasn't intentional, that my client missed court. Other than this other charge, which started off as a misdemeanor, I believe my client has no other criminal history, at least nothing significant other than potentially tickets. And, I mean, long story short, I think this is kind of boiled over to a degree that doesn't necessarily to be at, and that Tyler and I should be able to resolve it pretty promptly upon my client's release.
Okay.
Judge, that is my understanding. I've spoken at some length with Mr. Weiner and Mr. Knoll regarding this. Mr. Knoll, not what we would classify as falling on his sword, but he did tell me that he believed that Mr. Goodjoint did have COVID and was likely unaware of the hearing and did not intend to miss. While we don't believe that that is necessarily a defense, we're allowing him. We wouldn't agree to a PR bond, but I believe a surety bond of some amount that he has a bond company that he can communicate with and ensure that he is aware of all of his future settings. And then I do believe that Mr. Weiner and I can work out some resolution as to both of these cases in very short order.
Okay. I'll tell you what, Mr. Weiner, why don't you just go ahead and email that to Ms. Taberham? That way it doesn't get lost and going through the clerk's office and then present it to our office and back. Just since Mr. Woodwhite's in agreement, just go ahead and send that over to her directly, email, and get to me quicker.
It's bouncing off the satellite back to her. I appreciate it very much, Judge.
All right, so Mr. Goodjoint, we'll see you back on May 11th, and if you make bail, then it's going to be at 9 a.m. in the courthouse. Okay.
And Judge, that was my only case this afternoon. May I be excused?
Yes, thank you, Mr. Weiner.
Thank you. Thanks, Tyler.
All right, let's see. So Mr. Bruner, he's the last one.
Yes, sir.
Don't get up, Mr. Bruner, because Mr. Wood's not here. Give me a second. Let me look in your. State, do you have any information on Mr. Bruner? I show status of competency today.
Judge, we recently received a competency evaluation on Mr. Bruner in which I believe it's Dr. Compton, maybe it's Dr. Ingram. I don't recall exactly which physician spoke with him, but they found him competent. That's the last information. I have not spoken to Mr. Wood recently, specifically regarding this case.
All right, let me stand in recess for just a few minutes and do some checking.
Yes, Judge.
Oh, I'm sorry. I've got a couple of details with him that he should be pretty quick, but I understand there's a couple of explanations. Yeah, I think I want to give it how long. They said they sent it back. They said it's going to be long, we get on email. Staff and judge and.
Yes, ma'am.
Suspended on 10/30 for intact care and will resume once court has been concluded. Sure thing. Hey, it's Aaron. Are they having a medical issue back that they're having to take care of right now? Okay. Well, okay, I'll give that a try. Thank you. Hey, is this book in? Good deal. Are you guys under control now? Y'all good? Oh, well, I thought you were having a medical
Hey, Judge.
Hey, Jeff.
Hey, man. Yeah, hold on.
Just remember you're on YouTube.
Do what?
Recall that we are live on YouTube, just as a fair warning.
Hold on, bud.
All right, this is cause number CR 24-1 and CR 24-2, State versus J. Michael Bruner. We are set today on the status of Mr. Bruner's competency evaluation. The court has taken notice that Mr. Bruner was examined by the Dr. Timothy Ingram on the court's order, and that Mr. Ingram, or I'm sorry, Dr. Ingram has returned a report with an opinion and finding that Mr. Bruner is competent to stand trial at this time. So, Mr. Wood, any response to that?
Judge, I received that report yesterday, had an opportunity to read it myself this morning. What I've not had an opportunity to do quite yet is to discuss with Mr. Bruner that evaluation, and then also just have a conversation with Mr. Bruner in totality of everything that's going on. And so, Judge, I would like an opportunity to do that. I think I can get that done relatively quickly. And then once I get that done, Judge, I'll have a better idea on how I feel going forward with this matter.
Okay, court will set Mr. Bruner then for additional hearing on this competency report. And we'll set that for April 27th.
That sounds good, Judge.
Mr. Bruner, do you understand what we're doing here today?
Yes.
Okay. Do you have any, so, and you had an opportunity to speak with a little bit with Mr. Wood today, is that correct?
Very little, yes.
Right. And I think, Mr. Wood, did you indicate to the court that you would be meeting with Mr. Bruner next week?
Next week, for sure, Judge, maybe this weekend.
So Mr. Bruner and Mr. Wood will be there either this weekend, or he will see you next week to discuss that report before we come back to court. Okay, sir? All right. We will be adjourned in this matter, and we'll see everyone back on the 27th.
Thank you, Judge.
You're welcome.
Okay, here is our extra disc. Okay, thank you. So I guess I'm gonna get you to sit on up here in that corner seat. So you're a trustee? Yes, ma'am. And you're here for extradition? Gotcha. Okay, well, if you'd like to look over this paperwork, this is what the judge is going to be discussing with you.
I mean, I'm fully aware of what it is and I'm ready to sign it, actually.
Okay. Well, I'm gonna
So I
wait.
still gotta wait and do, okay. Might as well read it.
Yeah.